Customers can die from anaphylactic shock. This has happened. So it's important that if this is caught early enough, you can do a voluntary recall. Today, we're going to be talking about a very special topic. It is navigating FDA trouble with confidence. We're going to be going through first the phases of FDA enforcement actions. Next, we're going to be doing some case studies. So we're going to put it into play and show you kind of how these things play out. So first, we're going to talk about phase A, which is receipt. What we want to do is understand what a 483 FDA warning letter or detention notice truly means. So when you receive it, you want to make sure that you're reading that document sentence by sentence. Don't panic at legal language. This is where you want to get FDA compliance counsel involved so that they can help you understand what all of the language means and the significance of it, and then what kinds of actions FDA wants to see in order to satisfy them and meet the expectations they have for a thorough response. Next, identify the cited regulations and violations. So making sure that you understand each of the violations, what FDA is trying to say is a violation, and then finally logging critical deadlines. So having a really firm response timeframe. So for example, 483s are supposed to be responded to within 15 business days, as are warning letters. Detention notices usually have a due date for your response. And in the case of detention notices, which are on the import side, you do have to use a special system called ITAX to submit any documentation as well. But during this receipt phase, it's really important to just start prepping yourself, understanding what everything means, and what the requirements are in terms of timelines. That's very important. Next is the investigation phase. So this is definitely where we like to come in. Actually, we prefer to come in at receipt so that we can really get a jump on the timeline. If you're already in this phase, which is kind of, let's say, in the middle of that 15-day period, you've been gathering some facts as quickly as possible and trying to get them as accurate as possible in order to, prep the response. So at this point, you want to make sure that anyone on staff, you're putting together a team, anybody who is vital to this response, and that they are well aware of what the expectations are, so that you can get moving on correcting as much as you possibly can within that initial window. FDA loves to see that. Next, mapping the affected processes or products. So starting to look at your inventory, starting to look at the lot numbers affected, looking if there are any issues with processes, meaning, if you have SOPs that need to be updated, just at least identifying those things during this process so that you can start putting everything together. And then finally collecting, like I said, documents, putting timestamps and having relevant SOPs all gathered together so that you are preparing this response and at least preparing a plan, right? FDA doesn't necessarily need to see within that initial response everything done. They just want to see that you have a really thorough plan, that you've thought it through, that you've provided timelines that are realistic, right? We're going to get into that. Next, this is the response phase. So basically, this is drafting a corrective action plan. And of course, it needs to hold up, right? It needs to be something that meets the expectations of FDA and ticks all the boxes that they're expecting to see in terms of actions you're taking right away versus some of the actions that they know realistically may take some time. So you want to structure your CAPAs with root cause, the corrective action, and the preventative action. This doesn't necessarily have to be done completed right away, but you want to open up these corrective preventative action. You want to open these now and start those investigations and get them going and show FDA that you have started that analysis. Next, using clear, concise language, mirroring FDA's wording. I like to do a word for word, copy what they've got, paste it into my response, and then provide a direct answer to that. And then finally, as I mentioned before, setting realistic timelines and who is responsible for what. So making sure that you have not only your response to FDA with all of the timelines in it, and what you plan to do, but then having an internal working document, something like a shared doc between anyone who works in your firm, that they're aware of what's happening, what needs to be done, and what those timeframes are, because FDA does want to see you stick to whatever those timelines you've created. They want to see you stick to them. And if there's any reason you have to ask for an extension, it needs to be for a very good reason. And there are some cases where it's not a good strategy to ask for extra time because FDA will have already wanted to see that done, or they may continue asking more questions, pushing a little harder on the enforcement side. Next is the resolution and prevention phase. So this is hopefully where we can get you to. This is closing the loop and safeguarding future compliance. So this is where you have essentially already responded to FDA, you've provided your updates to FDA, and at this point, you're asking for a closure letter or some kind of confirmation that this matter is now closed in FDA's files. You're not always going to get that, but you can definitely ask for it. The idea with this phase as well, like I said, resolution and prevention. So we're trying to prevent things from happening again. So that's where those CAPAs come in, corrective and preventative actions. We are taking those preventative actions as well to make sure that we're not repeating the same things. That is one of the things FDA does not want to see, is a repeat of what's already happened. They want to see that it's closed out. If they continue to see the same violations coming up multiple times, that's when you're going up the totem pole in terms of enforcement action. So we don't want to be there. And then finally, training staff. This is something we do all the time, making sure a lot of errors in warning letters or anything involving, let's say, manufacturing, holding, distribution, tend to be around staff and properly training. So it's not just, oh, we're going to update our SOP. We're also going to train our staff on that new SOP and make sure that they understand the lessons learned in those scenarios. So now we're going to dig into a couple case studies. This is where we put it into action. And we have some examples here that are very close to situations that we've dealt with clients. They're not identical because we're not going to reveal confidential client information, but these are some really great case studies to put it into practice. So this is one on warning letters. This was a warning letter resolution. So we've got the client DEF Medical Devices, a mid-sized medical device company. They received a warning letter citing manufacturing deficiencies. So what are the actions that would be taken? Well, first, we're going to do a detailed review of the warning letter citations, make sure we understand what FDA is calling out. 2, we're going to focus on a root cause analysis through a facility audit. So we're trying to determine, in this case, with manufacturing deficiencies, what are the deficiencies? What are the issues? And what is the root cause? Where are they coming from? Next is submitting a comprehensive corrective and preventative action plan. That is your warning letter response, and you're providing that to FDA. So in this case, that's exactly what we did. And our outcome was FDA acknowledged that our plan was adequate, and we were able to ask FDA for a warning letter closure, and they did close that warning letter out. What's great about that is if you do receive a warning letter, it does go public, it does become searchable. What's great is when it can lead back to a closure letter. So even if reputation is somewhat harmed by the initial warning letter, in the eyes of your customers, when they see a closeout, it means to them that this is no longer an issue. There's no longer a problem here. And that's always a great thing to see. Next was a recall rescue. This is client Shanghai Foods, an international food company. So the challenge was they had a voluntary recall due to a labeling error with undeclared allergens or peanuts in their food. So FDA does have top 8 allergens. It used to be 7, now it's 8 allergens. Peanuts are on that list. And if it is not listed on your label, obviously this is an undeclared allergen. It can be a major problem, not just from an FDA perspective, but customers can die from anaphylactic shock. This has happened. Actually, there have been recent cases of this. So it's important that if this is caught early enough, you can do a voluntary recall. In this case, we were helping the client to create some CAPAs to make sure this didn't happen again, because obviously if there was an error, we need to trace back what was the root cause of the error. We were able to work with FDA's recall team. I'm very good friends with FDA's recall team. I've worked with them many times, and most of our team has as well. And then we created a customer communication plan. So that is making sure that the recall notices are communicated properly to the public and then to our customers, any distributors down the stream. And then finally, the outcome, we were able to close the recall in 6 weeks because it was voluntary. It was very limited lot numbers that were affected, and there was minimal brand impact. So it shows that when you engage counsel that knows what they're doing, you can have a really good result in a situation that otherwise could be extremely stressful and difficult to get through. Next, we're going to talk about a customs clearance situation. So this was involving a European gummy supplement brand called Herbal Gummies. And I have worked with quite a few gummy supplement brands. The challenge was products were detained for labeling errors. This happens very often. And when you are passing through customs, this is an extra level of scrutiny that you're going to be subject to. FDA and CBP customs work together, and they review products that come in, whether it be through ports or in different ways, right? Even through the mail. So in this case, products were detained for labeling errors. We were able to put together a notice of action response. That's what's received by the client when there is an error with a product at the time of import. We were liaisons with CBP and FDA representing the client on their behalf. And then we also created what's called a reconditioning petition. So in this case, because there were labeling errors, we were able to come up with a plan that FDA approved, which was to sticker the products, add these stickers to cover up any violative labeling issues and bring them into compliance. So the outcome was that the cargo was released and no fines were assessed, which if you create a plan and you're able to act out that plan, so in this case, your staff would go out and sticker those items, then you would be able to have it released. And in this case, we did. And we've had many, many of those situations where we were able to have products released based on a reconditioning petition. So this one is following an FDA inspection win. This was a US-based hand sanitizer manufacturer. The challenge in this case was there was a surprise FDA audit that flagged some ingredient issues where some of the ingredients actually were contaminated, and we had to jump into action quickly. Following an audit, if there are observations, FDA will issue what's called a Form 483, and you are required to respond within 15 business days. We were able to provide the response, stay in communication with FDA over time, providing ongoing updates. And then at the end, we helped the client with on-site training and auditing. The outcome was, thankfully enough, it did not lead to a warning letter, which, as I stated before, does go public. And the following audit with FDA was passed with flying colors. We did not receive another 483 the next time. So that was another amazing win in the case of an FDA inspection. All right, so if you're ready to move from panic to plan, if you're in the middle of the situation, or if you're just trying to avoid these situations, we can help on either side. If you just scan that QR code below, you can book a free 30-minute emergency FDA strategy call, or you can use that link, www.bustoslawgroup.com/get-started. You can also email us, info@bustoslawgroup.com, or call our phone number, 832-592-7851. Here, if during your waiting period between now and your consultation, you do want some additional information, we do have some additional resources. We've got some free webinars. We've got blog articles on our website, FAQs if you want to know a little bit more. You can also find us on LinkedIn, Facebook, And yeah, we would love to help you out if you're at that point in time where you do need the help and time is of the essence. So reach out to us today. Thank you so much for watching, and hopefully we'll see you soon.